She thought I would beg to save the marriage when she threatened divorce over financial control. Instead, I activated the postnuptial amendment and secured my investment portfolio. Her confidence shifted instantly when the court denied her request for emergency support. If you don't add my name to every single one of your investment accounts by Friday, I'm filing for divorce. She said it the way someone says it when they're absolutely certain the other person will fold. Calm voice, crossed arms, one eyebrow slightly raised. That particular expression she had spent years perfecting. She wasn't screaming. She wasn't crying. She wasn't even raising her voice. She was negotiating, and she genuinely believed she was holding the winning hand. I looked at her from across the kitchen island, my coffee mug halfway to my mouth, and I felt something I hadn't expected to feel in that exact moment. Not panic, not guilt, not the desperate, hollow urge to apologize and fix everything before it collapsed. I felt something that sat a lot closer to stillness, like a door had quietly swung open somewhere in front of me, and I was simply deciding, without rushing, whether to walk through it. Hey viewers, before we move on to the video, please make sure to subscribe to the channel and hit the like button if you want to see more stories like this. I'm 38 years old. I've been married to Victoria for 6 years. We live in a 4-bedroom house in the suburbs of Denver, the kind of neighborhood where people wave from their driveways on Saturday mornings, and the HOA emails are always about lawn height or someone's fence paint being 2 shades off. I work in asset management. I've spent the better part of 15 years building a portfolio that I protect the way certain men protect their peace, carefully, deliberately, and without apology. And Victoria? Victoria is a marketing director at a mid-sized firm downtown. She earns excellent money. She has her own accounts, her own credit history, her own independent financial life. That last part mattered enormously, because none of what was happening between us was ever about need. It was never, not for a single day, about survival or desperation. It was about something else entirely. To understand how we got to that kitchen, I have to take you back about 3 months to a Tuesday afternoon in an office that smelled like fresh coffee and carpet cleaner. We were sitting with our financial planner, a man named Derek, who had the kind of bone-dry patience that only develops after years of watching married couples argue about money, while he maintained a professional expression and waited for one of them to say something contractually useful. We were supposed to be reviewing a rebalancing proposal. We had barely gotten past the opening summary when Victoria set down the folder Derek had prepared and said, very pleasantly, "I just think that for us to truly function as a team, there needs to be full financial transparency between us." Derek had nodded in the measured way professionals nod when they're waiting for the other shoe to drop. I had nodded slightly less professionally. "We already have joint accounts for household expenses," I said. "Both of us can see every transaction in those accounts in real time." "I mean everything," Victoria said. "All of it." She smiled briefly at Derek, like they were 2 colleagues who both understood something I was willfully missing. That smile. That was the first time I'd heard the word everything used as a quiet ultimatum, and I filed it away. Here's something people don't tell you about certain kinds of marriages. The control doesn't always look like control at first. It looks like partnership. It looks like we should be more open with each other. It looks like I just want to feel included in our shared future. And because those words arrive wrapped in the language of intimacy, of love, of reasonable domestic expectation, you spend months, sometimes years, genuinely confused about whether the discomfort rising in your chest is a legitimate warning signal or just your own defensiveness making noise. I'd been working through exactly that confusion for the better part of 3 years. 3 years of telling myself the friction was temporary. 3 years of looking for the version of the argument where we both came out understanding each other better. 3 years of fundamentally misidentifying what I was actually dealing with. The investment portfolio she wanted access to was not marital property. That's not my assertion. That's what the postnuptial amendment we'd both signed 4 years into our marriage clearly and explicitly stated. And here's the thing that most people don't know about how that document came to exist. It was her idea. Not the protections on my side. Those were mine. But the postnuptial agreement itself had started as a conversation Victoria initiated. Her father had passed away 2 years into our marriage, and she had inherited a meaningful sum from his estate. She was rightfully cautious about what happened to that inheritance within the legal framework of a marriage. So she came to me and said she wanted something formal and binding that protected her inheritance as separate property. I agreed without any hesitation. I didn't want her inheritance. I had never wanted it. And I said so, plainly and without drama, and I meant every word. What Victoria hadn't fully anticipated was that my attorney, Ms. Hargrove, a meticulous woman who had been practicing family law for 22 years and who did not believe in documents that only told half a story, had drafted the postnuptial amendment to include symmetric protections. Symmetric, meaning both parties, meaning my premarital and separately maintained investment accounts were treated under the same legal framework as Victoria's inheritance. Same principles, same protections, same clear language on both sides of the ledger. Victoria had signed it. She had signed it because at the time, she was focused almost entirely on protecting her own inheritance. She'd read the document for what she needed from it, processed the parts most relevant to her primary concern, and signed at the bottom. Ms. Hargrove had walked me through it twice after execution and said, with that particular flat tone she reserved for important points, "This protects you both. Make sure she understands that." I had made sure, or I had thought I had. But here's what I've come to understand about people signing documents when they're only reading for one purpose. They miss things, and what gets missed doesn't disappear. It waits. The weeks after that first meeting with Derek were strange in a slow, accumulating way. Victoria didn't let the subject go. She brought it up at dinner twice more over the following 3 weeks, each time wrapped in slightly different language, slightly different framing. Once it was about estate planning. What happens to everything if something happens to you, and we don't have joint access? Once it was about partnership. I just don't think married people should have financial secrets from each other. Both times I explained, as calmly as I was able to, that I had a will, that she was a named beneficiary on specific accounts, that our estate planning had been done properly and recently reviewed. And both times she listened, appeared to consider it, and then pivoted back to the same core request wearing different clothes. She wanted her name on the brokerage accounts. She wanted visibility into portfolio decisions. She wanted, specifically, co-ownership. I didn't name it for what it was right away, but I'm telling you now, with enough distance to see it clearly, that what she was describing was not financial transparency. She already had access to all general financial information. I had never hidden our household situation from her. What she wanted was control, not partnership. Control over decisions I had made alone for 15 years, decisions that had nothing to do with our marriage and had been explicitly protected in a document we'd both executed. I did something that month I want to be honest about. I called Derek on a Thursday afternoon, without Victoria, and asked him one direct question. What are the legal and financial implications of voluntarily adding a spouse's name to accounts that are currently held as separate property mid-marriage? He was quiet for a beat. Then he said, "It complicates your protections significantly. Depending on how the accounts are retitled, it could be argued as a voluntary conversion from separate to marital property." What does that mean practically? It means the postnuptial amendment both of you signed might no longer cover those specific accounts if you voluntarily change the ownership structure. So the act of adding her name would potentially erase the protection. Could, yes. It depends on how it's handled, but the risk is real. Even if I was doing it under sustained pressure? He paused. "That's a question for your attorney," he said carefully. But yes, voluntary action, even pressured voluntary action, can complicate what happens in a later dispute. I called Ms. Hargrove the next morning before I'd finished my first cup of coffee. Ms. Hargrove is the kind of attorney who doesn't use unnecessary words. She reviewed the postnuptial amendment over the phone while I was on hold for 11 minutes, and when she came back, she was direct. "Your accounts are protected as written," she said. "Even if I voluntarily added her name under pressure?" I asked. "That's the variable," she said. "Voluntary retitling, meaning you chose to do it outside of legal compulsion, could be argued as a waiver of the protections embedded in the amendment. So I'd be surrendering a legal protection by doing exactly what she's asking me to do. That's the risk." "Yes. And if I don't add her name?" A pause, just brief enough to shift the register of the conversation. "Then you maintain the position you're currently in," she said. I didn't tell Victoria about that call. Not right away. What I did instead was give myself about a week of sitting with the full picture of our marriage. Not strategically, not with a legal outcome in mind. Just looking at 6 years of shared life and trying to see it without the softening that love puts around things you'd rather not examine too directly. Victoria and I had met in our early 30s at a conference in Chicago. She was sharp, quick, funny in a dry way that felt like a small ongoing challenge. She had the kind of confidence that didn't need validation. She was perfectly content being interesting to exactly the two people she was talking to and ignoring everyone else in the room. I had found that genuinely compelling. We dated for 2 years before I proposed. Real dating, actual courtship, honest disagreements, conversations about money and family, and what the next 20 years were supposed to look like. Those conversations had felt important to me. I'd been specific about my financial independence. I'd said clearly that I had built something before we met and that I intended to maintain it separately. And she had said she respected that completely. She'd said yes to the proposal without any hesitation. The first 2 years of marriage were mostly good, with the ordinary small frictions of two independent people building something shared. The shift, when it came, was slow enough that I couldn't point to a single date on a calendar and say, "That's the moment." It was a gradual recalibration. My long hours became resentment. My financial discipline became withholding. My preference for maintaining certain accounts separately became secrecy, then a pattern, then a wall you've put up between us. And somewhere in 3 years of quietly defending those things, my schedule, my approach to money, my professional habits, I stopped clearly understanding what, exactly, I was defending against. I believed I was defending reasonable personal principles. And I was. But there was also something else underneath the arguments, something I'd been avoiding looking at directly. She had decided, somewhere in years 3 or 4, that my independent financial life was a problem to be solved rather than a boundary to be respected. And she was extraordinarily patient about it. The Friday deadline arrived. I hadn't added her name to anything. I came home at 6:47 p.m. to a house with the lights already on and Victoria in the living room with what I can only describe as a prepared expression, like she'd been sitting with it all day, rehearsing the exact delivery. "It's Friday," she said. "It is," I said. "You didn't do it." I set my bag down near the door, removed my jacket, and looked at her directly. "No," I said. "So you're choosing your accounts over your marriage." I noticed the framing immediately. "I'm choosing not to alter legally protected accounts," I said. "Those are different things." She shook her head slowly, not with anger, but with the particular patience of someone who has decided the other person fundamentally doesn't understand what the real issue is. "You know what that tells me?" she said. "That you don't actually trust me." "I trust you," I said. "I don't agree with the request." Both of those things can be true at the same time. Not to me, they can't. Then we have a disagreement, not a betrayal. She was quiet for a moment. "If you can't commit to full financial partnership," she said, "I think we need to have a real conversation about whether this marriage is still working." And there it was. Not the explicit filing threat yet. That came later. But the first clear, unmistakable approach of it. A flare sent up into the sky. I want to be completely honest about what I felt in that living room. Not anger. Not the cold, tactical clarity that came later. Grief. A specific, quiet grief that arrives when you recognize that the thing you've been trying to save isn't quite the thing you thought you were saving. I had loved this woman. I still, in some complicated and increasingly honest way, did. But the person standing across from me using the marriage as leverage to reach protected accounts, that was not intimacy. That was a negotiation strategy with years of emotional investment stacked up as collateral. And I understood, standing there in my own living room at nearly 7 p.m., that I could not negotiate on those terms. Not because of the money itself. Because of what agreeing on those terms would say about who I was and what I was willing to let be taken from me without consent. The next 2 weeks were a controlled frost. Polite at meals. Distant in the evenings. She made no moves toward warmth. I made no moves toward surrender. And the lack of surrender confused her. Because if you watch the pattern of how Victoria operated in standoffs, in our marriage, in professional situations she'd recount over dinner, in conflicts she analyzed and replayed the way some people replay games, the underlying assumption was always that the other person would eventually break. Not from weakness, from love, from the fear of losing the life they'd built. She was counting on the fact that the house, the history, the shared routines, the accumulated weight of 6 years, that I was more afraid of losing those things than I was committed to protecting what I'd built before she ever existed in my life. She was wrong, but she hadn't confirmed that yet. 3 weeks after the Friday deadline, I came home to find a business card sitting on the kitchen counter. A family law attorney. She hadn't tried to hide it. It was face up, centered in the middle of the granite countertop like a placed chess piece. I picked it up, read the name and the listed practice areas, set it back down in the exact same spot. When Victoria came downstairs 20 minutes later, I was sitting at the island with a glass of water. "Do you want to talk about this?" I asked, nodding toward the card. "I had a consultation," she said, staying standing. I wanted to know my options. That's fair, I said. She paused in the way someone pauses when a response doesn't match the reaction they prepared themselves for. I'm serious about this, she said. I know. I'm not testing you. I didn't say you were. Another pause, slightly longer than the first. You're really not going to fight for this marriage, she said, and there was something in her voice that wasn't strategy. It was closer to genuine disbelief. I'm not going to give you control over accounts that are legally protected and were agreed upon in writing by both of us, I said. Fighting for a marriage and refusing an ultimatum are not the same thing, but you're treating them like they are. She shook her head. Victoria, I said, keeping my voice level. The postnuptial amendment we both signed addresses this directly. The accounts are separately documented and protected on both sides. She looked at me. That document was about my inheritance. It was symmetric. Your attorney reviewed every page of it. My attorney drafted it. Both sides are protected under the same framework. She went very still, the particular stillness of someone recalculating. I'd like you to read it again, I said. The whole thing, before we go any further. She did read it again. I know because 2 days later, I heard her on a call with her attorney from the other side of the study wall. I wasn't positioned to eavesdrop. I wasn't trying to listen. But her voice was audible enough that fragments reached me. I heard, "What do you mean it covers both sides?" Silence while the response came through. Then, sharper. But I was told this was primarily about the inheritance. More silence. Then, lower and more controlled. Okay, walk me through it. All of it from the beginning. And then another long stretch of quiet during which something was being explained that she had not been prepared to hear. I went back to my laptop and didn't say a word about it when we passed each other in the hallway that evening. What happened over the following 2 weeks was something I found almost clinical to observe from the inside. Victoria stopped bringing up the postnuptial amendment. She didn't acknowledge that she'd reread it. She made no reference to her attorney's explanation. What she did instead was pivot, cleanly, deliberately, with the practiced fluidity of someone who has always known how to redirect a narrative when the current one stops doing what she needs it to do. Suddenly, the argument was no longer about account access. It was about the emotional architecture of our marriage, about distance that had accumulated over years, about how she'd felt for a long time like she was living beside someone rather than truly with them, about how my availability, emotionally, physically, conversationally, had diminished in ways she'd never been able to articulate clearly until now. I listened to all of it. I want to be clear about that. I genuinely sat with what she was saying and tried to hear it honestly, without immediately cataloging it as a tactic. Because buried underneath the strategic pivot, there were real things being said. There was genuine unhappiness in our marriage. Real distance that had accumulated over years, year over year. And I was not blameless in how that distance had formed. My hours had been long by choice. My emotional availability had narrowed in ways I told myself were sustainable, but which had clearly registered, over and over, as absence. There were conversations we could have had 3 years earlier that we never had. I acknowledged all of that to myself, privately, with something that felt like honest and overdue regret. But I also noticed something with equal honesty. This unhappiness, if it was real, and I believe parts of it were, had been available for discussion at any point over the previous 6 years. Not one of those conversations had been opened until the postnuptial amendment became a problem. The timing told me everything about the purpose. The intimacy complaint was real, and it was being deployed now as a second front, because the first front had collided with a legal document that wasn't going to yield. I called Ms. Hargrove on a Thursday afternoon. "I think she's going to file," I said. "What's making you read it that way?" She's pivoted off the financial argument. She's building an emotional narrative. Distance, availability, connection. The works. "That tracks," she said. "It's a standard repositioning when the asset challenge runs into a solid postnup and can't find a viable crack. What do I need to do?" "Nothing that changes the paper trail," she said immediately. "Don't move money. Don't voluntarily retitle anything. Don't add her to any account under any framing. Don't have significant financial conversations with her outside of documented settings. And if she files, the postnuptial amendment will be the first document on the judge's desk in any property division proceeding. Your accounts are clean, the maintenance is separately documented, and her signing attorney was present and independent. She'll challenge the amendment. Almost certainly. Standard arguments, signed under duress, insufficient disclosure, scope wasn't adequately explained. You'll see all three. She had her own attorney. I know. And that attorney made a modification request on her behalf during drafting. A beat. That matters, Ms. Hargrove said. A lot. There'll be an emergency motion, you think? Almost certainly. Temporary support and probably a request to freeze the investment accounts while the proceedings run. Can they freeze them? They can request it. Whether the court agrees depends heavily on what the documentation shows. Ours will be solid. How long before a hearing on an emergency motion? 2 to 3 weeks. I'll push for the earliest slot. What do you need from me? Everything. Premarital account statements. Postmarital statements showing no commingling. The amendment in full with all signature pages. Derek's formal statement confirming separation of funds. Any correspondence from the brokerage showing account ownership history. You'll have all of it by Monday morning. Good, she said. We'll be ready. I want to tell you what living in that house was like during those weeks, because I think this is the part of the story that gets lost in the external narrative of legal proceedings and courtrooms. We were still living together, not out of affection, not out of some last-ditch impulse toward reconciliation, out of pure, practical logistics. She had nowhere to go that made financial sense while the proceedings were active, and I wasn't going to voluntarily leave a home I'd co-purchased and maintained for 4 years. So we existed in parallel. 2 adults sharing a floor plan, a refrigerator, a driveway, the careful choreography of a shared space from which all the sharing had quietly evaporated. She ate dinner before I got home most evenings. I made coffee at 6 a.m., well before she came downstairs. We crossed paths in the hallway and exchanged sentences like, "Your package is on the front step," and "The plumber confirmed Thursday at noon," and "The dishwasher is clean." It was the most exhausting kind of silence I have ever maintained in my life. Not the silence of people with nothing left to say. The silence of people who have said everything internally and have decided that the cost of saying it out loud is no longer worth paying. 9 days after she filed, she knocked on the door of my study. Not the sharp, purposeful knock of confrontation. A quieter one. I looked up from my laptop. "Can I talk to you for a minute?" she asked. "Go ahead." She came in and sat down in the chair across from my desk, the client chair, the one that faced me, the one she'd never sat in before. She looked tired. Not strategically tired. The actual kind. The kind that settles into someone's face after weeks of legal consultations and recalibrations and slowly accepting that the map you'd drawn of a situation doesn't match the territory at all. "I think we both know this got out of hand," she said. I waited. "I'm not saying I want to stop the process," she said carefully. Is there some version of this where we sit with a mediator? Come to something without putting it in front of a judge?" I studied her face. Not to be unkind, I want to be honest about that. Because I needed to understand what this conversation actually was before I responded to it. What would mediation need to accomplish for you? I asked. An agreement. Something we both consent to, outside of court. An agreement about what, specifically? She looked at the window, then back at me. "The accounts," she said. There it was. Even stripped down to honesty, even in a quiet room at 9 at night with the legal proceedings already running, it still came back to the same place. The same destination, different route. "Victoria," I said, "if what you're looking for is a mediated pathway to the investment portfolio rather than a litigated one, my answer is going to be the same in both rooms." "It's not just about the money," she said. And I believe part of her meant that. A real part of her. "Then tell me what it's about," I said. A long silence. The kind you don't fill, because the other person needs to find their way to the honest answer without you guiding them there. "I've always felt like you kept the most important part of yourself behind a wall," she said quietly. "And the money was the most visible version of that wall." "I hear that," I said. "But you're not going to change it. Not by dismantling legal protections that exist for documented and legitimate reasons," I said. "No." She nodded. Slowly. Not in agreement. In the way someone nods when they finally accept, fully, that a door they'd been hoping might open was never going to. She stood up. "Okay," she said. She walked out of the room. I sat there in the quiet for a long time after, not working, not reading, just sitting with the complicated reality that you can understand someone's pain completely, hold it with genuine compassion, and still not give them what they're asking for. Those two things, understanding and refusing, can live in the same person at the same time. It doesn't feel clean, but it's honest. The emergency motion hearing was scheduled for a Tuesday morning at 9. I arrived early. Ms. Hargrove was already at the table, her documents arranged in the precise and color-coded system she applied to every proceeding. account statements in one section, the postnuptial amendment in another, Derek's formal statement in a third, a certified timeline of asset maintenance behind a fourth divider. She had brought more documentation than strictly necessary, because that was her approach to preparation. When you're relying on documentation, you bring all of it. Victoria came in with her attorney, Mr. Pennington, a man whose suit communicated expensive in a way I suspected was designed specifically to make opposing parties feel they were already behind. I did not feel behind. Victoria sat without looking at me. I didn't push for eye contact. Mr. Pennington opened with 3 arguments delivered in the smooth rhythm of someone who had made similar arguments in similar rooms and had found them effective before. The first was equitable interest. Victoria had made consistent financial contributions to the household over 6 years, which had effectively subsidized my ability to maintain and grow the investment portfolio, and she therefore had a legitimate equitable claim to a portion of it. The second was defective execution. The postnuptial amendment had been signed under conditions where Victoria lacked full understanding of its symmetric scope, and the court should examine the adequacy of her legal representation at signing and whether the disclosure process had been sufficient. The third was financial hardship. Without emergency spousal support during the proceedings, Victoria would face immediate and serious financial disruption. Ms. Hargrove responded in the organized, unhurried manner she applied to everything. On equitable interest, she introduced the certified account history showing the investment portfolio had been funded exclusively from premarital assets and income maintained in complete separation from joint finances, with the joint account records showing parallel and proportional household contributions from both parties. She introduced Derek's formal statement confirming that in 4+ years as our financial planner, he had never received any instruction to move funds between household accounts and the investment portfolio, and that to his direct knowledge no commingling had occurred at any point. On defective execution, she introduced something that landed in the courtroom quietly but with significant weight. She introduced the certification letter from Victoria's own signing attorney, a woman with over 2 decades in family law, clearly stating that she had reviewed the amendment with Victoria across 2 separate sessions prior to execution and that in her professional judgment her client had full comprehension of the document's terms. She introduced the amendment's drafting history, including a formal modification request submitted by Victoria's attorney during the drafting process. And then she placed the original draft and the executed amendment side by side and let the comparison speak for itself. The modification request had been made. The modification had been incorporated. And the document Victoria ultimately signed was different in one specific provision from the document originally drafted, changed at her own attorney's request on her behalf. You don't negotiate specific language in an agreement you haven't understood. That was the argument, and it was airtight. On financial hardship, she introduced Victoria's employment records. 6-figure salary, continuous and uninterrupted. No evidence of financial disruption. No evidence of emergency. The judge asked Victoria's attorney 3 questions. The first was direct. Can you clarify the basis for the emergency designation in this support request, given the income documentation in the record? Mr. Pennington explained the request was forward-looking, anticipating potential disruption during a lengthy proceeding. The judge made a note and moved on. The second, the record shows the petitioner's counsel submitted a modification request during drafting that was incorporated into the final agreement. Does that affect your disclosure adequacy argument? Mr. Pennington acknowledged it complicated the position somewhat and suggested the court should nonetheless examine the broader disclosure scope. Another note, and then the judge said something that wasn't a question. It was a statement delivered in the tone of someone who has read hundreds of these documents and has limited patience for arguments that the paperwork doesn't support. The postnuptial amendment before this court is clearly drafted, symmetrically structured, and executed with independent legal counsel representing both parties. The petitioner's own attorney made a substantive modification request prior to signing that was incorporated into the final document. This court takes that as direct evidence of comprehension and full independent review. I am not finding adequate basis to freeze the investment accounts or to grant emergency spousal support at this time. The emergency motion is denied. I want to describe what Victoria's face looked like in that moment. I've thought about this more than any other single image from the entire experience. Not with satisfaction. I want to be careful and honest about that. Not with the cold pleasure of watching someone lose, but with something I can only call solemn recognition. She had walked into that courtroom with the posture of someone who fully expected the room to confirm what she already knew to be true, that I had been unfair, that the accounts were exposed, that the legal system would look at the situation and correct the imbalance she had decided, privately and completely, existed. And when the judge said those words, "I am not finding adequate basis," something in Victoria's posture didn't collapse so much as quietly reorganize. Like a building that doesn't fall, but settles somewhere deep in its foundation after an impact it absorbed differently than it expected to. She looked at Mr. Pennington. He leaned in close and said something very quietly near her ear. She nodded once, and then she looked across the courtroom at me, just briefly, not with anger, not with humiliation, with something I think was the plain, unguarded expression of someone who has arrived, finally, at the understanding that a situation is exactly what the other person said it was all along. I held her gaze for a moment, not to claim anything, just because I wasn't going to look away. The days after the hearing were different. The proceedings were not resolved. We had property to negotiate, logistics to address, months of paperwork still ahead. But the fundamental texture of everything had shifted. The leverage she had spent the better part of a year constructing around our marriage, the belief that the portfolio was accessible, vulnerable, reachable, had been addressed. The court had read the document, reviewed the full record, and told her attorney plainly that the argument wasn't there. 2 weeks after the hearing, Mr. Pennington reached out to Ms. Hargrove. The message, translated from formal legal language into plain English, was this: "Our client is prepared to discuss a straightforward settlement on standard marital assets only." Ms. Hargrove called me on a Friday afternoon. "They're abandoning the portfolio challenge," she said. "What are they proposing instead? Clean division of marital assets. House equity split evenly. Joint accounts divided by contribution. Vehicles retained individually. Standard dissolution." I thought for a moment. The support claim? Withdrawn entirely. I sat with that for a beat. "What's your read on the shift?" My read is that Mr. Pennington looked at the signing documentation, Derek's statement, the modification history, and the account records, and told his client that continuing to pursue the portfolio would be expensive, time-consuming, and almost certainly unsuccessful. "He's not wrong," I said. "No," she said. "He's not. I want to be honest about the house. The 4-bedroom in Denver with the front porch and the HOA emails and the specific quality of light in the kitchen at 7 a.m. I had loved that house, not as a symbol of success or arrival. In the plain, private way you love the specific shape of somewhere you come home to every night. The sound the front door made when it caught properly in the frame. The way the backyard looked in the morning after the first snow of the year. The particular quiet of Sunday before anyone else was awake. Agreeing to list it as part of the settlement was the piece of the whole thing that actually hurt in the way grief hurts. Not sharp, but deep. Not the portfolio. Not the legal fees or the proceedings or the months of managed silence. It was signing the listing authorization papers. I sat in Ms. Hargrove's office on a Wednesday and signed 3 documents in succession, and then sat back and looked at the ceiling for a moment before reaching for the 4th. She didn't say anything. She put the signed pages in order and let the moment exist without filling it. That was one of the most quietly decent things anyone did for me throughout the entire process. The settlement finalized 8 weeks after the hearing. House listed, sold, equity divided evenly down the center. Joint accounts split by contribution, calculated from the day we opened them. Vehicles retained individually. She kept hers, I kept mine. The investment portfolio, untouched, intact, exactly as documented from the very beginning. Not a dollar moved. Not a single account altered. Exactly as it had been on the morning she gave me the Friday deadline. Victoria and I did not speak during the final weeks of the process. Everything went through the attorneys, every question and response routed through proper legal channels. On the day the final paperwork was executed, I was in a conference room I'd sat in a dozen times before. Victoria was down the hall, in a separate room, with her own attorney, signing her set of documents. We never shared the same space. Which felt, in the end, like an accurate conclusion to something that had been operating in parallel for much longer than either of us had chosen to name out loud. 3 months after the finalization, I sat across from Derek for a standard quarterly review. He looked at the numbers, made several notes on his pad, then looked up at me. "You're in a solid position," he said. "I know," I said. "We went through the review the way we always had. Talked through a rebalancing opportunity in the fixed income allocation. discussed a sector position that had underperformed its 12-month projection, considered a new instrument one of his other clients had raised, and whether it fit my profile. Normal, steady, professional conversation about the patient work of building something carefully and maintaining it through disruption. At the end of the meeting, as I was putting my jacket back on, Derek said something without looking up from his notepad. "For what it's worth," he said, "I've watched people lose everything they spent 20 years building because they made an emotional decision at the exact moment that required a clear one." I paused. "You didn't do that," he said. I thanked him and walked out into a November afternoon in Denver, the air carrying that specific cold that comes down from the mountains before the first real snow, and I stood on the sidewalk for a moment before walking to my car. I wasn't celebrating. There is no version of a marriage ending where the person who walks away with their assets intact has won something good. You don't win a divorce. You survive it more or less whole, or you come out with parts of yourself missing that you have to slowly account for. What I had done was refuse, consistently and with documentation, to let someone else's ultimatum rewrite a structure I had built honestly and carefully over 15 years. That was the whole of it. About 6 weeks after that review with Derek, my friend Will called on a Saturday morning. Will was one of 3 people who had known what was happening from the start and had been decent enough to let me process it without turning it into a long conversation about what I should have done differently at each stage. "How are you actually doing?" he asked. Not the version of that question you ask to be polite. The one you ask when you actually want to know. "I'm okay," I said. "You sure?" I thought about it before answering. "The hard part isn't the legal piece," I said, "or the money, or even the house, though that one hit differently than I expected." "What's the hard part?" "Accepting that the story I was telling myself about the marriage wasn't the full story," I said. "That I kept finding reasons to believe things were better than they were because the alternative required more honesty than I was ready for." Will was quiet for a moment. "That's not a character defect," he said. "That's just what love makes you do. You protect the version of things you want to be true." "Maybe," I said. "You handled it right, though. You didn't burn everything down out of anger. You didn't do anything reactive or stupid. You held your ground and let the documentation do what documentation is supposed to do." "I got lucky I had the documents," I said. "You didn't get lucky," Will said. "You planned. Years ago, quietly you planned. And when you needed it, you just let the planning work." He wasn't wrong. There's something I want to say about postnuptial agreements, because I've turned this over many times in the months since. When people hear that phrase, postnuptial agreement, the assumption tends to be that the person who wanted one went into the marriage already planning the exit. That having those protections in writing means you were never fully committed. That it signals distrust dressed up in legal language. I disagree. What it meant for both of us, at the time we signed, was that 2 adults agreed in writing to be honest about what each of them had brought to the partnership, what had been built independently, and where the legal line between separate and shared property sat. She wanted that clarity for her inheritance. I wanted it for my portfolio. The agreement was symmetric. Symmetric means both. Both means it operates for whoever ends up needing it, regardless of which direction the marriage eventually moves. She had come to the table with an attorney. She had read the document with that attorney across 2 sessions. She had made a modification request that was incorporated before she signed. She had signed. And then, for years later, when the symmetry of that document stopped serving her interests, she chose to read it as something it was not. That choice, the decision to reframe a mutual and documented agreement as an injustice done to her specifically, was the thing that ended our marriage more definitively than any argument about account access or financial transparency. Because what I understood, standing in that kitchen on the morning she gave me the Friday deadline, was that she didn't only want the accounts. She wanted to be the one who decided what fair looked like. She wanted to be the authority on what was reasonable to expect of me. And I was not going to give anyone, regardless of how much I loved them, unchecked authority over something I had spent 15 years building with discipline, patience, and care. I'm writing this from my apartment now, smaller than the house. No front porch, no HOA, a kitchen that doesn't have that 7 a.m. light I still think about sometimes, but quiet in a way I've been learning, slowly and without rushing, to appreciate rather than mourn. The portfolio is exactly where it was when all of this started. Better positioned, actually. The November rebalancing was well-timed in ways I hadn't fully anticipated. I'm still at the same firm. Still working the same hours, by choice. Still building the same way I always have, methodically, patiently, without expecting anything from markets or from people that I haven't verified through evidence or documentation or direct experience. That last part might sound cold written out plainly. I've decided it doesn't matter how it sounds. Because the alternative, trusting structures that exist only in assumption, relying on goodwill that isn't backed by anything legible, that cost me 3 years of slowly mounting confusion and a marriage that had hollowed out before I was willing to be honest with myself about it. Something happened about 2 months ago that I've been sitting with quietly. I ran into Victoria at a coffee shop downtown. Complete coincidence. I hadn't planned it. I wouldn't have chosen it. She was at a table by the window with a friend, and I was in the ordering line when I noticed her friend look at me and then back at Victoria with the very specific expression that means is that. I looked over. Victoria gave me a small, measured nod. Not cold, not warm, just honest. I nodded back. That was the entire interaction. No conversation, no scene, no loaded silence that demanded something more. She looked okay, not devastated, not secretly triumphant about some development I didn't know about. Just a person who had shared 6 years of a life with me and was now having coffee by a window on a Tuesday in a city we'd both been in long before we ever knew each other. I ordered my coffee. I left. And I've thought about that brief, quiet moment in the months since as a kind of accurate conclusion to everything. Not satisfying in the way stories are supposed to be satisfying. Not dramatic or cathartic or full of clean meaning. Just two people who once knew each other very well, who acknowledged each other with a nod, and moved on with their mornings. The plain, neutral grammar of something that is simply over. I won't sit here and tell you I made perfect decisions throughout any of this. I didn't. I stayed in a marriage that had started to feel like a protracted negotiation at least 3 years before it actually ended. I had conversations about control and financial pressure that I should have had years earlier, and with far more clarity than I brought to them. I told myself, for too long, that the friction was temporary. That the version of Victoria I'd fallen in love with and the version who was systematically testing the edges of what I was willing to give up were the same person in a rough season. They were the same person, but the rough season was the structure, not the weather. And the moment I finally understood that, clearly, without softening it into something more manageable, was the exact moment I stopped being afraid of what came next. If there's one thing I'd pass along from any of this, and I'm not offering it as wisdom, only as something that was true in my specific experience, it's this. Know what you've built. Know what's documented, what's protected, and why those protections exist. Not because you're planning for failure. Not because you're anticipating the worst from the person you love. But because clarity is not the opposite of love. Clarity is what remains when the pressure is at its highest. And when someone hands you an ultimatum wrapped in the language of partnership and intimacy and shared futures, the right response is not to panic. It is not to surrender out of fear of loss. It is not to dismantle something real in exchange for temporary peace. The right response is to take a slow breath. Read the document. Trust the structure you built when you were thinking clearly, before the emotional stakes were this high. And whatever you do, don't mistake stillness for surrender. Because sometimes the person in the room who isn't saying anything, who isn't begging and isn't breaking and isn't reaching across the distance to fix something that isn't fixable that way, sometimes that person is the one who understood the situation clearly from the very beginning. The accounts are fine. The apartment is quiet on Sunday mornings in a way I've started to genuinely like. The coffee is better without the particular dread that used to attach itself to the day before it even started. I don't know exactly what comes next, but for the first time in a long time, that uncertainty feels like open space rather than approaching threat. And honestly, for right now, that's more than enough.